Hi, this is Week 5 podcast on the Judiciary. The third branch of government, the Judiciary, is often overlooked because it might be considered the weakest branch of government of the three. It has the power to make decisions, but it has no real army or police force to enforce those decisions. It has to rely on the executive for that. But even though it's not a branch that we hear much about in public until a big case that orders a policy change might come up at the highest levels, without this branch, if you think about it, we would have no way to keep order in society. We'd have nobody to tell us exactly what our laws mean and whether they meet constitutional standards. In other words, are they legal under the written constitutions? So in our society, when you have a disagreement or there's a gray area in the law, instead of getting angry and picking up the closest hammer and going after your adversary, the two parties can go before a judge and work it out in court. So ironically, what looked like the weakest branch of government on paper is actually the most popular whenever you ask people in polls about which institutions they respect the most in government. The Supreme Court always does better on those questions than either the president. He can waver between 40 and 60% approval, or even less, or Congress, which now rarely gets above 15% approval. The Supreme Court always has a very high majority of approval. So remember that word federalism, which describes having a division of government between cities, states, and the federal levels. Well, the same idea of federalism applies to courts. In this country, different courts rule on different bodies of law. And because of federalism, each state has its own system of courts, in addition to the national system that we have. Federal judges are supposed to interpret and rule on U.S. constitutional, statutory, and administrative law in the federal courts, while the state judges do the same, except they do it on the constitutional, statutory, and administrative law of their own states. So they would be using state law as precedent, and sometimes they might pull from federal case law if analogies can be made in these particular cases. So we have there a dual court system. The federal court system, which includes the Supreme Court, gets all its power from Article 3 of the Constitution and the concept of judicial review. But the interesting thing is, if you go and look for the words judicial review anywhere in the Constitution, you won't find them. This is one of those powers that the judiciary acquired later, and it was argued at the time, rightly so, that there was no way that the judicial branch could be truly independent from the other branches unless it had the power to decide whether acts by the other two were constitutional or not. So there is this case, which mentioned in your book, Marbury versus Madison, decided in 1803. And that was really the first case in which the Supreme Court struck down as unconstitutional part of a law that Congress had already passed. And that had never happened before. So you may ask, if there's no judicial review written into the Constitution, why would the other branches decide that they would be okay with this and live by the judge's decisions? Because in a sense, they're giving up a lot of power there. Well, remember what I said about the court being the most popular with the people. And there's something to that. Elected officials, who of course get their power from the people, they never want to be seen as violating a court's ruling, knowing that the courts really have a high approval rate among the public. So, in that sense, the courts end up getting quite a bit of political power indirectly. Now, this is a good thing in those times of crisis, when we really, there's controversial decisions made by the court, but they're still followed. For example, some of you might not remember this, but you can read about it. Many officials were outraged in the Supreme Court's decision in Bush v. Gore from 2000, which basically stopped the recounting of the votes in Florida during the 2000 presidential election and handed the election to President George W. Bush. And many people thought that was unfair, but they went along with it. They followed the decision because to do otherwise would be even more dangerous and unsettling for the nation. So it's a good thing the court had quite a bit of credibility there. Another example, there's quite a few people who disagree with the court's decision on abortion. That's the 1973 Roe v. Wade case. But there are no states, at least yet, that are willing to completely ignore that ruling. And when they do, or they have restrictive laws that may conflict with it, well, that comes up for judicial review again. Okay, the current federal court system is made up of three major levels. First level are the federal district courts. There's 94 of those. These are trial courts in which you have evidence heard, witnesses testify, the lawyers argue. The judge makes a decision based on facts, evidence, and the arguments. Every state has at least one federal district court. The biggest states, like for instance California, has more. We have 4 federal court districts. You can look at the map that's included on the week module. It shows you that Humboldt's judicial district is the northern district, while those of you who might live in Orange County would be in the central district. And then you go further south, the San Diego County is in the southern district. So the trials that are pertaining to federal laws and the U.S. Constitution, they end up getting conducted in the district where an infraction or injury occurred. Okay, the next level of courts is called the Court of Appeals. And there are 13 of these appellate courts. 11 are organized geographically. And the same principle holds for the district courts, in that cases are heard in the circuit where an infraction or an injury occurred. You'll see from the map that California is located in the Ninth Circuit. So that means, in a hypothetical case, let's say you were driving and stopped by a police officer and your car was searched and you thought that was an illegal search and seizure. Well, that would first go to the district court, and then in an appeal, you would appeal that to the Ninth Circuit Court of Appeals, because that's where the injury occurred in California. The appeals court has 3 judges, and their job is really to review the procedure and judgment in the district court cases, because it's an appellate court, and they want to determine if everything was done appropriately. And then they'll either affirm the district court's decision or reverse it. Then you have the third level, the highest court, that many of you have already heard about, the U.S. Supreme Court. We call this court SCOTUS, S-C-O-T-U-S, as an acronym, the Supreme Court of the United States. And this court is also primarily an appeals court that hears appeals from the 2 lower levels that I mentioned. Article 3 does specify that there are certain cases that originate in the Supreme Court itself, but those are probably going to be cases in which, say, 2 states are suing each other. Most of the cases it hears are appeals from the lower courts. So the Supreme Court gets so many applications for courts, and most of those applications are just never heard. There's not enough bandwidth for the justices to hear them. So not everybody has the right to appeal all the way to the Supreme Court. You have to be allowed in a sense. I think the court hears, on average, 1% of all the appeals that are filed. So you really have, if you want to appeal that search and seizure case all the way up, you really only have a 1 in 100 chance of doing so. So how does a case actually get to the Supreme Court? Like I said, most of them come through the appeals system from the lower federal courts, most likely from a circuit court of appeals. You can also get a case that reaches the Supreme Court through an appeal from a state Supreme Court. And most of these cases will concern a state law, which are properly enforced, that violates a federal law or the U.S. Constitution. So about 10 to 30% of appeals come from the state Supreme Courts. Now, to actually make it through the gate, 4 of the sitting justices have to agree that the case is worthy of being heard by the Supreme Court. Keep in mind, that's not a majority. There's 9 justices. So actually only a minority, 4 of them, have to agree. And then the court issues what's called a writ of certiorari. That's a big word, Certiorari, writ of certiorari. And if a case is denied certiorari, then the decision of the court below the Supreme Court stands, and it's not heard by the Supreme Court. And the justices don't have to explain why they might not accept a case or not. Okay, I won't go too much into how the case moves through the Supreme Court, how it's argued. You can see that in your book. But I do want to get into why justices might write opinions. And so after a case is decided, the Chief Justice, if he's in the majority, assigns himself or an associate justice to write a majority opinion. If he happens to be in the minority, then the most senior justice in the majority assigns the opinion writing. And so different opinions are written, the majority opinion, the dissenting opinion. There can also be a third type of opinion called a concurring opinion, sort of a middle ground. That's when a justice agrees with the majority's conclusion in the case but does not agree completely with the reasoning. So they file all these opinions because actually it's quite important. Not just the decision is important, but the justice's thinking is important. So you might want to look back. Let's say a similar case comes up in 2024. They might want to look back at the dissents written in 2013 to see if they can gather any important information. Now there's this other concept called stare decisis. Really just means let the decision stand. And that's a type of tradition that involves using precedents. That means cases that have happened in the past and have been decided to guide judicial reasoning. So judges can disagree with rulings and precedents, but by stare decisis, they still must take the precedents themselves into account when they decide how to rule. So, sure, they can reverse them, but they still have to take those precedents into account. Now, they might take these precedents into account in different ways depending on what's called judicial philosophy. Your book goes into this, talks about why there might be different justices might look at something in a different way. Someone might be an originalist, someone might be a textualist, another person might be a modernist. I think the important thing to remember is that really the justices disagree on exactly how much the Constitution should be a living document. When I say that, I mean how much, should we consider the Constitution with today's meanings and values versus taking into account, for instance, how the original framers were intending the text, or what the text itself says, aside from any other modern values and debates. So this, because there are different philosophies, obviously there's a lot of disagreements among justices. One person might think something is constitutional, while another person does not. And this is the great thing about the courts. It's a constant battle, and there's a different makeup of the courts pretty much in every decade. So we get a lot of different opinions on what the Constitution means. Now you might ask, well, we've talked about checks and balances for the other branches. Where's the check on the judicial review? And while there's no formal check, remember, judicial review is not even written into the Constitution. There is a check in that the Senate has the ability to confirm appointments to the Supreme Court. But the tradition of judicial review shows that justices practice a good deal of self-restraint in rulings. That's a kind of check. They may even decide something that flies in the face of their own personal values because they're following legal tradition. Also remember that there's a type of informal check and that Congress still has the power to pass any laws it wants that may negate just judicial rulings. And it can even refuse to disperse funds that might be needed to carry out the rulings that the judges hand down. So a few things to ponder before we go. How comfortable are you with the Supreme Court being the final say on these laws, especially when there's a 5-4 decision? And that's how most of the most controversial decisions are made, although there are plenty that are that we don't hear about that are consensus opinions. But for those 5-4 decisions, keep in mind that there's only one person Justice Anthony Kennedy, who was often the swing vote in those cases. At least your book says he was for 85% of the time in those closely divided cases of 2010 and 2011. So my question is, isn't that placing a lot of power in only one person's hands, and that person's deciding for millions of people, especially if that swing vote is always the same guy? Thanks a lot, and I'll see you next time.